So, let's talk about a legal rule that sounds kind of dry, but is actually the secret engine behind countless court cases. It's called the business records exception, and it's a powerful shortcut that helps decide when a simple piece of paper, like your bank statement, can be trusted as real, solid evidence in court.
But why do we even need a shortcut for something so simple? I mean, why can't you just hand a judge a bank statement to prove you paid a bill? Well, the answer gets to the heart of a huge legal headache, one that would pretty much bring business to a grinding halt if we didn't have a clever fix.
All right, here's what we're going to cover. First, we'll look at the big problem this rule was created to solve. Then, the common sense solution the law came up with. We'll break down the checklist for what makes a record trustworthy, and dive into the big debate over how powerful this rule really is. Then we'll see how it all works in the digital age, and wrap up with the ultimate question. How do you balance convenience with a fair trial?
Okay, so first up, let's get into the problem this exception was designed to fix. And it all boils down to one of the most famous and frankly frustrating rules in all of law, the rule against hearsay.
So what in the world is hearsay? You can just think of it as secondhand evidence. A bank record, for example, is just a statement that was written down outside of the courtroom. And normally you can't use that piece of paper to prove what it says is true. Why? Because the court wants to hear from a live person who can be questioned and cross-examined, not from a silent piece of paper.
And you can see how this creates an absolute logistical nightmare. I mean, just imagine for a second, if this exception didn't exist, for every single transaction in a case, you'd have to track down the exact clerk who recorded it and drag them into court to testify. You'd have to haul these giant, dusty original ledgers into the courtroom. The entire legal and business world would just stop.
So, to prevent that kind of chaos, the law came up with this really elegant, common-sense solution. We're going to look at the version from Queensland, Australia, the Evidence Act of 1977. But honestly, it's a great example of a legal idea that's been developing all over the world since the 1800s.
And the whole solution starts by defining a book of account in these incredibly broad terms. We're not just talking about an accountant's official ledger here. The law gets that things like diaries, invoices, delivery logs, and bank statements are all part of the normal rhythm of doing business. And because of that, they can be treated as reliable.
You see, this law wasn't just some abstract idea. It had three very real, very practical goals. It had to let lawyers inspect records for sure, but it also had to free business people from the ridiculous task of lugging original books to court. And, maybe most importantly, it aimed to make these records prima facie evidence. That just means the court accepts them as true on face value, and it's up to the other side to prove they're wrong. Okay, but it's not a total free-for-all. You can't just submit any old document you find. To use this shortcut, the record has to be reliable. So, the law sets up what you can basically think of as a trustworthiness checklist to make sure the evidence is legit.
And that checklist, it's all about routine. First, you've got to prove the record came from an ordinary business book, not some document that was whipped up just for the lawsuit. Second, the entry itself has to be routine, made in the usual flow of business. And if you're using a copy, you just need someone to swear that they checked it and it's accurate. The whole idea is that records created during the normal, boring day-to-day of business are inherently trustworthy.
Right, but here's where it gets really interesting, where lawyers and judges don't always see eye to eye. The big question is, just how powerful is this exception? Is it just a rule of convenience to avoid carrying heavy books around? Or does it fundamentally change what actually counts as evidence?
So on one side, you have people who take the narrow view. They argue that this law is just about convenience, period. It saves the banker a trip to the courthouse with the original ledger, but that's it. A copy is still subject to all the same hearsay challenges the original document would have been.
But then, you have the broad view, and this one is a much bigger deal. This interpretation says the law does way more than just allow copies. It makes the entry itself actual evidence of the transaction. So this isn't some minor convenience, it's a massive exception to the hearsay rule.
And of course, like in so many legal debates, there's a third view, trying to find a middle path. This argument says, yes, the exception applies, but only for transactions where the business itself, the bank for example, was directly involved. It wouldn't apply to, say, a note a bank manager made about a private conversation between two customers.
So that brings up a pretty big question. How does this old legal principle, something born from ink and paper ledgers, actually hold up in our modern world of laptops, servers, and digital data? Well, the law has actually done a pretty good job of keeping up. Modern evidence acts now include specific sections just for computer-generated documents. The core ideas are exactly the same. Is the digital record trustworthy? Was it created in the normal course of business? Basically, the law now treats a server log or a database entry the same way it once treated a paper ledger, as long as the computer system that made it is reliable. And all of this brings us to the ultimate balancing act. On one hand, you've got this incredibly convenient, efficient shortcut. But on the other, you have a person's fundamental right to a fair trial. So how do the courts weigh these two things, especially when someone's freedom could be on the line?
To keep things fair, the law has some really powerful built-in safeguards. First, remember that prima facie thing? It means the evidence is never absolute. It's just the starting point, and the other side always gets a chance to challenge it. And most importantly, the judge always holds the trump card. They can throw out any record if they think it would lead to an unfair trial. These rules are there to make sure that efficiency never, ever trumps justice.
And that kind of leaves us with one last big question to think about. This rule was designed in an era of handwritten ledgers. Now we live in a world of automated transactions, blockchain, and complex algorithms that generate our data. So, is this old-school legal shortcut still the right tool for the job? Is it still striking the right balance between efficiency and the timeless demand for justice? That's the question our courts are going to be wrestling with for years to come.